All right, folks, we're going to get started. If we can get focused a little bit. It's almost 5 past, and we're not on Cayman time here. So, offshore funds, onshore litigation, marriage of convenience or necessity is the topic. If you're looking for the boring topics, they're next door. Okay, so leave now if you want, or in the marriage sense, forever hold your peace. Welcome. We're going to do a quick introduction of ourselves and then move into some scintillating topics. And have some fun, hopefully, this afternoon. So that's me. That is the worst picture I've ever taken at the firm. For some reason, they thought these giant headshots of lawyers would be a good idea, bad idea. I'm Jonathan Sabloni. I'm a partner at Nixon Peabody in New York and Boston. I am the chair of the firm's private fund dispute team, which is a fancy way of saying that I lead our essentially hedge fund group, private equity group litigation team. The rest is there. I'm not going to read you all the wonderful things that the marketing people have to say about me, other than my practice, as a lot of you in the room know, consists of representing liquidators, offshore liquidators, and onshore disputes, hence the name of the topic, as well as both general partner managers and investment limited partners, LPs, in fund disputes across the private spectrum, from hedge funds to private equity funds, real estate, venture, tax credit, you name it. If it involves an alternative asset, I handle it. So, and I'm thrilled to be here today and share some of my experience with some of you, and hopefully learn a little bit from you as well. There you go.
Thank you. Hi. I actually don't mind that photograph because it was taken 5 years ago. I didn't like it at the time. Now I think it's great. It says I'm a 20-year veteran. I'm now a 25-year veteran. I'm afraid we're not very good at updating our website. I have been a litigator in Cayman since 2005, at the bar before that, partner at Walker's since the 1st of May 2009, and you'll see from the difference between that photograph and me appearing here 5 years later what the 5 years since the global credit crisis have done to a very busy asset recovery lawyer and contentious liquidation specialist in Cayman. It's been a very, very busy 5 years, and you'll see from what's on the slide there that we cover a wide range of work, but mainly it's financial services type litigation.
So I just want to say, many of you have commented that Colette and I should complement each other on this panel because we're so different. So this is our first time doing one of these together, so bear with us. Somebody said chalk and cheese. I'm not sure if I'm the cheese or you're the chalk, but we'll find out. So I just wanted to lay the foundation a little bit, give a little bit of an introduction. Everybody in this room should know this, but where have we been? You know, this is like, I don't know if you remember Admiral Stockdale way back, the vice presidential nominee. You know, where am I? Why am I here? Why are we sitting here? Someone else is getting started. So 2007 to 2009, I put 7 up there because, as many of you know, although some don't put the fund crisis, the credit crisis that far back, there were some major fund collapses in 2007, which I think sort of presaged the credit crisis. So 2007 to 2009 is the credit crisis, serious lack of liquidity. It impacted even healthy funds, as we began to find out, because investors were scrambling for cash. Anywhere they could get liquidity, they got it. So even the healthy funds became very unhealthy as investors began to redeem out. There began to become enhanced investor scrutiny on the fund documents. I'm sure Colette had the same exact experience. For the first time, you had investors who invested billions and billions of dollars into funds, and for the first time actually began to read the documents into which they had invested, and began to realize, wow, I don't have any rights at all. So there was enhanced pressure on that, increased pressure by regulators in the US, certainly the SEC, what we now call the FCA in the UK, and obviously in Cayman and BVI. Criminal investigations began. People began to be thrown in jail. Everybody except sometimes, I guess, the Wolf of Wall Street at first. And then bankruptcies, liquidations, and controlled wind downs. So that's our backdrop, which led us to liquidation and litigation. Madoff, I like to say, spawned an industry. I think as sad and as hard as it was, I think a lot of people sitting in this room have been earning a living for a number of years off Bernie Madoff in some respects. Fraud and insolvency claims began to trickle down. Clawback disputes began to come into vogue and are still in vogue. And feeder funds and fund of funds really got caught in the middle, because as a practical matter, they were victims and yet they were also targets. European investors, offshore liquidators, and of course US institutional investors decided, I'm not going to play the gentleman's game anymore of not engaging in litigation. There's too much at stake. We've lost too much. And as a practical matter, I have to do something to discharge my duties to my ultimate beneficiaries. And we saw liquidators begin to pursue third-party claims, both, and investors as well, both here in the US and offshore. We really have three issues, which I'm just going to breeze through real quick, that we're going to talk about today in terms of the litigation context. The first is redemption freezes. You're all familiar with this, but many funds right now have been locked up for years. I would submit, and I think most lawyers who put these fund documents together would submit, that putting the redemption freeze provisions in the fund documents were never meant to last for years. 4 or 5 years at this point. They were meant as temporary precautions against essentially a run on the bank. But they've been in place for years now. Gating the fund, in my opinion, has been used now over the past number of years to actually hide the true value of the assets. Because as a practical matter, if you have to keep the gates up because you can't sell an asset because it's a liquid, at some point that illiquid asset becomes what someone's willing to pay you for it, not what you marked it for. So that's becoming an issue we're dealing with. The fund, obviously, in these conditions is unable to attract new capital. It's forced to rely upon essentially non-existent organic growth, of course. And the fund documents, as some of our LP clients have learned, give unfettered discretion in many respects to the fund manager, which resulted in a rush to redeem and claim creditor status. So that's redemption freeze. Then we have NAV concerns, which played into this. Fair market value versus net asset value. I think they teach the same definition in the UK as they do in the US, which is fair market value is what a willing buyer will pay to a willing seller, both under no compulsion to buy or sell. Many people thought that's what net asset value meant, but not really. Net asset value is a little bit different. So fair market value is not net asset value. And as a result, we have this real disconnect in these funds. Wide latitude has been given to the fund managers in terms of setting net asset value and the procedures they use. And there's limited scope of audits, and it's hard to value these assets. A lot of these assets in these funds, as you all know, are very difficult to value. They don't have, it's not like looking up a stock price on NASDAQ or on the US or on the New York Stock Exchange. It's a lot more art than science. The 220 fee structure in the hedge funds and the open-ended funds also played into the NAV issue. Obviously, the higher the value of the fund, the higher the fees which the fund manager can take. That's the 2%. And the bigger the run-up, the bigger the 20%. So there was certainly incentive for the fund managers to rely on increased NAV markings. And then managers lost interest in some of these funds because they've hit the high water mark. There's no more 20% upside. And there's really no more fee incentive to sit and manage a fund that has no liquidity and is going nowhere. And as a result, investors lost confidence in NAV. And then finally, liquidity risk. The credit crisis exposed this, but it's been around for a long time. The contagion spread to even, I would say, safe haven assets. I have a client that got caught up in an auction rate security issue. They thought that auction rate securities were the equivalent of cash. They thought wrong. Liquidity issues even hit those safe haven securities. It also, the lack of liquidity, highlighted the drift of the funds into long-term and undisclosed positions. Suddenly, you began to understand that the fund might have invested in positions that weren't going to pay out for 6, 7, 8 years, even though the investor thought maybe they had liquidity at any point that they wanted it. There was a rush to redeem. And what essentially happened, in my view, is that the illiquidity effectively transformed open-ended funds into closed-end funds, except they're now closed-ended funds with absolutely ill-fitting management structures and fee structures. So it exposed all of these problems in the fund industry. And we found that the redemption freezes, plus NAV concerns, plus liquidity risks, eventually equaled massive offshore liquidation and onshore litigation. And with that, we're going to begin our discussion of, is offshore litigation even an option in some cases?
Or onshore litigation, for that matter. So, I mean, the first thing to think about when you've got a defendant target in your sights is check very carefully for something like an exclusive jurisdiction clause. Certainly in the Sphinx Funds case, PwC Cayman was joined along with a number of other defendants to proceedings onshore, to proceedings in New York, and that was dismissed in New York because of the exclusive jurisdiction clause. So do think very carefully about whether there's a contractual arrangement, which means you cannot go onshore. The other thing that's worth thinking about in deciding whether to go offshore or onshore is the very important issue of where are the assets? Where's the defendant and where are the assets? Because the most important thing before you start litigation is making sure that you can enforce your judgment. We heard this morning on the judges' panel of the case in Bermuda, where Mexicans are suing Bermudans in I think it was Arizona, and 10 years on, they've got their judgment, which is now being challenged in the Bermudan courts where they need to enforce. It's a shame that they didn't consider in 2003 what they were going to do with their judgment. So consider the jurisdiction issue. And of course, the jurisdiction issue should not only be, will the onshore court, if it's an offshore party suing, will the onshore court accept jurisdiction, but will that acceptance of jurisdiction be accepted in the court in which you wish to enforce the judgment? Because that's always a tricky issue, particularly with New York, where, as I understand it, simply making a phone call to someone there is enough for the New York courts to think they have jurisdiction over you.
It is. You know, let's talk a little bit about three things: funding, costs, and pleading. And I think to many of you practicing in the U.S., this will come as no surprise. For those of you who primarily are used to the courts in Commonwealth jurisdictions and specifically offshore, they are sort of shocking. Moving in reverse order, pleading. You know, in the United States, we have notice pleading. That essentially means that as long as I lay out the elements of a claim, I can move forward with it. I can say, upon information and belief, I believe the following is true, and I can make out a claim, where that would never fly in a Commonwealth jurisdiction, certainly not in Cayman, and certainly not in BVI. It is a huge, it depends on your perspective here, but if you're a plaintiff looking to make out a claim, it is a huge, huge benefit in the United States or in New York to be able to have notice pleading. You don't need to have all of the evidence to back up those claims, and it is a big difference. Even alleging fraud. You know, in the United States, we talk about the fact you have to allege fraud with particularity. Well, that doesn't mean the same as what you have to do to allege fraud offshore. All pleading fraud with particularity means is, I was told by this person at this time this statement. And that's all you have to say. I've now pled it with particularity. Colette told me that she would meet me in this room at 3 o'clock. She did not show at 3 o'clock, and therefore she has committed fraud. I've pled it, it's particular, I move on. But that's not the case offshore.
It is certainly not the case offshore, and sometimes it's very important to be able to plead your case in a way that brings it above the threshold for recovery if there are indemnification or exculpation clauses in the agreement that governs whatever the relationship is between the potential plaintiff and defendant. And in Cayman and in the UK and as far as I know in most offshore jurisdictions, it's professional misconduct to plead fraud or other serious misconduct without credible evidence. Now, that doesn't have to be credible, admissible evidence at the time of the pleading, but in order to pursue the case to trial, you need to have credible, admissible evidence too, or you are guilty of professional misconduct. So there's quite a high bar to get over to get your proceedings off the ground if you are going to allege serious misconduct in an offshore jurisdiction.
And there's a reason in New York why we are alleging these other types of claims like fraud. We're not trying to be thrown into jail. What we're doing is, you know, as I said before, these fund documents were drafted for the managers, for the funds, and therefore it's not surprising that they are very, as you know, very, very beneficial to fund managers and very difficult for investors to bring claims. So if you were to look at the four corners of most of these fund agreements, you wouldn't have a claim against the manager or against anybody else. What we're able to do in the United States more effectively, certainly than offshore, is to allege off-contract claims, fraud, misrepresentation, negligence, breach of the implied covenant of good faith and fair dealing. Claims where you could say, Judge, you know, we don't need to worry about that provision of the agreement because we have a different claim here. So that's why we're concerned about fraud, breach of fiduciary duty, misrepresentation, those types of claims.
I think another difference between the pleading standards in the offshore-onshore world is I will say anyway, the clarity and the concise nature of the pleadings, or at least as they should be, the pleadings in the offshore context. You're not just telling a long, long story. Prolex pleadings are deprecated. You need to be precise. You need to set out the facts, not the evidence, and you need to be clear. How is it in New York, John? I've seen those 150-page pleadings.
Only an Englishwoman could kick you under the table really hard and then smile at you. We'll just leave that one there. Let's talk about costs for a minute as well, because I think costs, and this is from an American perspective, and it's meant in all sincerity. My experience in the UK and offshore has been that the cost issue begins to drive the dispute. In a way that is perplexing to American lawyers, meaning that we spend more time fighting over fee applications, spending time fighting over fee sanctions. You know, I filed this motion and I won this motion, and who's going to pay the fees? And it ends up being the proverbial tail wagging the dog. We have a $1 billion fund dispute, and we spend 3 days fighting over who's going to pay £10,000 for legal fees on this issue. So the U.S. system, of course, is different, the American versus the English system. In the American system, everybody bears, with certain exceptions, everybody bears their own legal costs, which means the bar to the plaintiff bringing a claim is much lower. Colette and I were talking outside, and I have a client in the UK that could not bring an action in the UK simply because the company could not afford the bond that the English court required them to put up in order to cover the potential legal fee award to the other side. We ended up bringing that claim in the United States, and within a couple of months settled it, and everybody had a very happy result. That's the type of access to the court system that maybe you don't have as much of given the cost system. And it's a big difference. It's a benefit to the plaintiff in that case.
It is a benefit to the plaintiff, and of course it's also a detriment to the defendant who finds himself on the wrong end of some proceedings that have no legs at all, but he has to spend quite a lot of money to see off. We are, of course, throughout the offshore world, as far as I'm aware, loser pays jurisdiction. Costs are always subject to taxation. It's fair to say that taxation can take on a life of its own too. There is always the risk that you end up just spending more and more money on fees, and I take John's point on that. But the security for costs powers that go along with the loser pay jurisdiction are important to protect defendants, in my view. It stops shell companies from pursuing litigation that doesn't have merit. And one of the cases, that sometimes very seriously large security for costs orders are made, and many millions of dollars sometimes, where the litigation is large, and that protects the defendants. And the courts, of course, they're not supposed to go into the merits when they decide whether or not you have to put up what John refers to as a bond, but if the merits are overwhelmingly in favour of the plaintiff, then you're unlikely to get a security for costs order as a defendant.
And I think this plays into a larger theme. There are some broader themes here. And I think the broader theme on costs is really what the point of litigation really is in the different jurisdictions. My experience dealing in the English system and offshore is especially the lawyers, when they think about a claim, they think about, I am bringing this claim and I am bringing it to bring it all the way to fruition, through trial, and to get a judgment and to enforce it. And that is their mindset from the moment they take on the matter. In the United States, litigation tends to be used much more as a business tool. Very few claims ever make it to trial. I think the percentages now are between 2 and 5% of all matters get to trial. They all settle before then. And the concept is we're going to use litigation as a business tool in order to try to settle matters and try to resolve disputes amicably during the litigation process. And that's a critical distinction, because that begins to explain why some of these different paradigms fit in. Obviously, if you're paying your own legal fees, you have less of an incentive to fight to the very, very end, because you can look at what it's going to cost you to fight to the end and say, well, if I can settle it and get rid of my risk and avoid those fees, it makes more sense.
Doesn't that run the risk of it being used as a tool for, for blackmail, for extorting money where it's not due?
Well, there's a fine line between blackmail and leverage, but yes, it does. But what I would say about that, and I believe this is true, I mean, if you're using litigation in a manner which is completely unscrupulous, in a manner where there really is no merit whatsoever to the claim, that will become quickly obvious, and you can be sanctioned. It's not the Wild West. But in cases where there are claims that perhaps are not as strong, there is less of an incentive to fight to the end. Because if I'm in the English system, if I think I can win this claim, if I'm a lawyer or I'm a client, it's in my best interest to fight to the end and get my cost award.
I think that's a very fair point.
Yeah.
It does probably increase the chances of the case proceeding.
Yeah.
And also, I think I'm right in saying that we start off more gently with our proceedings, with the pleadings. Discovery is less onerous. We'll come on to that in a moment. But certainly with your deposition process, the costs escalate and the pressure is on from a much earlier stage, certainly as I understand it.
That's correct, and we'll get into that, but that's exactly right. So the American system, in my view, is geared much more towards exacting pain on the parties to force them into an agreement, whereas in the English system, it really is designed to do what it was originally intended to do, which is to resolve disputes in a court of law. Big difference. Let's talk about funding for a minute. This is a very hot topic, which I know I've talked to many of you in this room about in the last couple of days, so I know you're interested in it. And that is, how do you pay for these fees? And there are two sort of things floating around. We all know we can pay lawyers by the hour, which is the way we've all come to understand the way we pay our professionals. But there are two other types of ways to pay lawyers, which are a little less traditional offshore. One is through contingency fee agreements, and the other is through private financing, through financing firms that now will agree to finance litigation. And the latter has become very hot in the United States, and I know has been used offshore because I have funding clients who are in Cayman and BVI all the time looking to sell their wares. So I'm going to leave it to Colette to explain what Champa Tea and Maintenance are, because to an American lawyer, there's concepts we learned in law school and then have promptly forgotten about. So Claire, what are they?
Well, I must admit, I've had to look up the difference between Champa Tea and Maintenance this morning because I couldn't remember from law school. So maintenance is encouraging litigation without legally recognized motive to do so. And Champa Tea is agreeing to share in the proceeds of litigation in return for assistance. But generally it's a term of art that's used together. Now, why do we have this common law rule against Champa Tea and Maintenance? Well, the cases suggest it's directed against wanton and officious intermeddling with the disputes of others. And it's also intended to prevent the corruption of public justice.
Intermeddling.
Intermeddling.
That's an English word if I've ever heard of it.
Wanton intermeddling. Now, it's not right to say that in Cayman, I can't really speak to other offshore jurisdictions, but it's not right to say that you can never get conditional fees. You can if the case requires it, but you do have to have court sanction. So when the employees of BCCI who had no money and needed legal representation to try to recover some of the money that had been taken out of their pension funds, wanted to bring litigation in Cayman, they were permitted to do so, with the lawyers charging nothing if the case didn't win and an uplift if the case did win. And we've also aware of a much more recent decision in which the Chief Justice has allowed a significant uplift in lawyers' fees and no win, no fee if the case is lost. So where you are going to get into difficulties in the Cayman Islands is if you want to share the proceeds of the litigation. If there's a contingency fee arrangement, that's less likely to get through the door.
Right, and what we've seen from a practical standpoint on the ground is that we are seeing judges offshore, especially in Cayman, giving sanction to liquidators to use funding arrangements in onshore litigation here in the United States. And primarily on the theory that since the United States legal system allows for those types of agreements, that they can sanction them. But what they will not do, and properly so, I think, is sanction litigation in the offshore jurisdiction using funding type arrangements like that, or in any jurisdiction where a funding type arrangement would be illegal or unethical.
Yeah.
So
And we've had a very helpful ruling recently from Mr. Justice Jones in Cayman, where he set out the terms in which he would be prepared to sanction the use of contingency fee type arrangements where the litigation is taking place in a jurisdiction where those arrangements are not void for Champa Tea or maintenance. And so he did sanction in that case lawyers to bring a contingency fee based claim, and he said that there were certain terms, though. First of all, the liquidators and the attorney who was going to enter into the contingency fee arrangement had to have very detailed terms. A plain sort of engagement letter wouldn't do, and the court wanted to see what the terms were. It was important also that the liquidators maintained control of the litigation, and I think the court will be astute to avoid any sort of poison pill type arrangements that mean that once the litigation starts, it can't be stopped by the liquidator without having unpalatable consequences.
Right. And then lastly, just let me spend a moment talking about applicable law, because we talk about litigation in the United States or in New York, but most of the fund agreements, offshore fund agreements, will stipulate that the law of the offshore jurisdiction applies. So you're in the sort of difficult position of arguing Cayman or BVI law to a New York judge, which oftentimes spawns motions to dismiss with attached expert affidavits about what Cayman law says or does not say. The reason, as a practical matter, it doesn't change very much is that most onshore judges are loath to dismiss something based upon competing affidavits as to what Cayman law allows. Most judges will defer those decisions on the ultimate merits further down the road, thus opening the right to discovery, and therefore not dealing with it until towards the end of the case, which hopefully by then it'll settle. So it's not exactly applying Cayman law or BVI law in that sense.
I follow. Well, providing these opinions on Cayman law is quite a nice little line of business for us in Cayman, but I'm still waiting for the day when I'm asked to be cross-examined. I'm not looking forward to that. Hasn't happened yet, happily.
So let's talk a little bit about discovery, Colette. And you know, this one is, and I want to be clear to our, especially the English lawyers in the room, discovery and disclosure are not the same thing. They simply are not. Discovery in the United States is wide-ranging. It goes far beyond anything you could possibly do in disclosure. With the advent of the electronic discovery rules in federal and now in state courts, we typically have cases in all of these jurisdictions where the amount of data being exchanged is in the terabytes. And that is, you know, millions and millions and millions of pages of material. It is depositions, which can go on and on and on, and it is all, and can be all, very public. And so discovery is a very blunt instrument in the United States. If you're on the plaintiff side or even the defendant's side, it may benefit you because you will have access and get access to information you may not otherwise been able to get any other way, and certainly maybe not through disclosure. But that is a tool. And it is a tool that I have found many liquidators have asked to have access to the New York courts specifically for, because they'll say, we believe that this other party has information, but if we just go through the typical English system, we're never going to find it. We need a discovery process that gets us more than what we'd be entitled to in an offshore or in a UK court.
Well, in Cayman, we still think that our discovery process is quite wide because it's wider than the discovery process in the UK, where the rules changed about 10 or so years ago. We have a documentary disclosure by list where you have to produce documents that support or undermine your case and or that may help the other side, or that put the other side on a train of inquiry with regard to those things. So we don't often use depositions. In fact, we have a provision in our Grand Court rules for depositions, and it's been described by Mr. Justice Quinn as an unloved and unwanted orphan, and it's been made clear that it will only be used in rare and exceptional cases. And I don't know if anyone from Cayman in the room knows of a case where it's been used, but certainly I don't. So it is much narrower in Cayman, it's fair to say, but still wider than the UK now.
And I want to stress, especially in the fund context, that depositions really are the key sometimes to proving the disputes. And the reason is, you know, if you can send a document request to a fund manager or to anybody, and you're going to get in return a sheath of financial material, primarily spreadsheets, that are going to do absolutely no good. What you need to do is sit somebody down who understands those documents and begin to cross-examine them. You know, where did this number come from specifically? How did we get here? How does this get to this point? And you can't do that offshore. And so, again, the premium here is on being able to figure out the facts, determine what actually happened, and being able to depose the people who actually drafted those documents, put those numbers together, made the decisions, really can make a very, very big difference. So it's a difference.
Now, in Cayman, we have an implied undertaking that the documents that are disclosed in your litigation will only be used for the purposes of that litigation unless the court gives you leave to use them in other ways. Do you have a similar restriction in the US?
It depends. Yes and no. I mean, if you just exchange discovery material, then for the most part, you can do pretty much anything you want with it. However, in most cases, one side or the other insists on some type of confidentiality order or stipulation, which will actually say that it cannot be used in certain other ways. But you don't have to agree to that, and a court doesn't have to allow that. And I think even with those confidentiality orders, the way they're worded tends to be broader even than your rules. So there's certainly much more wider access and use to material in the United States. And like anything else in life, once you learn a fact, even if you can't use the document, you now know the fact. If I'm a liquidator and I'm suing a auditor, and I have a different case against the same auditor, and I learn something in the litigation, I may not use that document, but I now know about that fact, and of course I'm going to use that fact in a way that's going to be beneficial in my other matter, so it can be used that way.
And how about disclosure with third parties? Because we have very limited third-party disclosure, Norwich Pharmacal and Bankers Trust type relief. What's the position?
Yeah, we were talking about this earlier too. It's completely open-ended. We have, in the federal system, we have Rule 45, similar rules in the state system that allow you to subpoena non-parties. And the discovery rules and obligations are just as broad vis-a-vis those third parties as with parties in the case. Now, as a practical matter, most judges will ask you to tread more carefully against true third parties that might have information, because they're not part of the litigation, they didn't sign up for this. But the way the rule is written, I can get just as much information from a third party, and I can certainly take that third party's deposition. So, for example, if I've got a case that a liquidator is suing a former fund manager, we can subpoena the auditor of the fund, and we can depose the audit company and learn everything we need to know through that process without ever naming the auditor. And then if we discover that there's information that would lead us to believe we have a claim, we can then either sue the auditor or bring them into that case. Yeah. And I don't think that's something that's as readily available.
No, I mean, there's a possibility, I suppose, that they might come within the sort of innocent facilitator of a wrongdoing under the sort of Norwich Pharmacal, but it's not that likely. The usual target for the Norwich Pharmacal type relief is the registered office, provider, and banks.
Right. So, Colette, let's talk a little bit about recognition and enforcement of judgments, and I think that's more, if you get a judgment here in the United States, that's lovely, but as we heard during the judges panel today, that doesn't always get you very far.
Well, we were helpfully taken through the provisions for recognition and enforcement at common law, and also a statute from the judge from the Bahamas Court of Appeal. In Cayman, we do have a statute for the recognition of judgments. It doesn't even apply to the UK, believe it or not. It only applies to Australia. We then have to rely on the common law, and then that requires you to prove that the court had jurisdiction, that the judgment is final and conclusive, it's not impeachable, and it's not contrary to public policy. Having said that, it isn't all that difficult to enforce a properly obtained onshore judgment in the Cayman Islands, and I've seen it done in a fairly large amount of a fairly large Florida award recently, where we were involved, and I think it took something like 6 weeks from start to finish to get the judgment enforced, and it's a summary judgment application, and it can be done very quickly.
Good. In the United States, the process is similar. It can be done quickly if it's been done right. The states have a uniform act that most of them have passed that deal with the enforcement of foreign judgments. I recently got a UK judgment entered in the United States in New York, and it took a month. You know, you can do it relatively quickly. Where issues come into play are if it's a default judgment, You have to show that the court had jurisdiction over the person or over the party, or where, for whatever reason, the foreign jurisdiction is suspect in terms of bias. I had a case trying to recognize a Polish judgment in the United States, and in that one, the Polish government was a party, and there was some allegation that perhaps the court maybe put its thumb on the scale in favor of the government's claim, and that took a lot longer to get around. But I think the enforcement piece is relatively straightforward if you have a claim where both parties were represented in a jurisdiction that's universally known as being fair. How about bankruptcy and liquidation? I'll just say at the outset, I'm not a bankruptcy lawyer, but I believe that in my view, the liquidation process is a much better way in some respects to handle wind downs than Chapter 11 bankruptcies in the United States. What do you think, Claire?
I would agree with you. It depends on whether you're the debtor or the creditor, doesn't it? Because if you're the creditor, you definitely want to go down the offshore winding up route. If you're a debtor, you want to scramble to get your Chapter 11 in as quickly as you can. I've certainly been involved in a scramble to get Chapter 11 where we were acting for debtors. The winding up process was started first, and a winding up order was made, which is a little inconvenient for us. But happily, we managed to get it set aside because new rules had come into place and they hadn't been followed properly, and the Court of Appeal set the winding up order aside. And before the new proceedings were started, we managed to get into Chapter 11. So it can work quite well for debtors. Certainly, I think for creditors, you're much better off with the winding up process, which puts a liquidator in charge.
Right, and we're going to flip it here. Normally, we're trying to promote onshore litigation because of the tools that it provides a plaintiff, in a lot of cases, an offshore liquidator. But when I represent investors in offshore funds that are in trouble, the first thing I do is call an offshore lawyer and say, we may want to file a winding up petition. That to me is that process, and the way it's handled and the way it's administered is far superior to what we could do here in some respects. And
once you've got that liquidation process, it's important not to forget the powers that the liquidators have once they've been appointed. And certainly under the company's law in Cayman, there is an ability to cross-examine certain categories of people, including the former directors, and that can give you the advantage in the Cayman Islands that you get through the deposition process in the US.
Right. So our last big wordy slide, we talked about the pleading standard, and we talked about discovery, and we talked about the legal fees. Let me talk a little bit about what we've labeled liberal and expansive application of the law. Again, this is a cultural, I would say a cultural disconnect between both sides of the pond, shall we say. In the English system, obviously you wouldn't recognize it today, but the American legal system grew up as a common law system following English precedent. You look at the two systems today and they seem as far apart as could possibly be. I think the difference is the U.S. system has become so expansive and so liberal, it looks nothing like the system that spawned it, several hundred years ago. And that matters if you're trying to stretch the law. In the U.S., we specifically say, when we talk about even our ethics opinions, that you have to bring a claim that's allowed by the law or is made in good faith in an attempt to have a good faith expansion of the law. Well, what does that mean? That means the law is supposed to be flexible. It's supposed to be organic. It's supposed to grow and stretch. And that's part of the fabric that American lawyers and the American jurisprudence system weaves for itself, whereas that's not as much the case offshore.
Well, I mean, I think anyone who's followed the common law over the hundreds of years would be able to say, well, of course we're flexible, and we're very flexible, but perhaps not quite as elastic as the US system.
There's a lot of elasticity in there, is there? And on that liberal sort of an expansive application of the law, I'll give one just quick example that, makes a big difference for this type, for fund litigation specifically. As many of you know, very few LP investors in the offshore funds hold those shares, those interests in their own name. Typically, there are custodial banks that are the legal shareholders, and there may be field nominees and others that provide barriers between the ultimate beneficial owner of the fund and the legal shareholder on the books of the fund. And in your courts offshore, you need to bring suit in the name of the actual shareholder. And I've been involved in cases where, or I should say I've come into cases after the fact, where lawyers, even offshore lawyers, have made the mistake of trying to bring suit in the name of the beneficial owners.
It wasn't us.
It was not you, I agree. But good law firm. And what happens? The matter is dismissed, it's stricken out, and a cost order is entered because nobody has standing to bring those claims but the legal shareholder. What you need in that instance is the legal shareholder either to be the party in the case or to give you sanction to bring suit in their name. Well, good luck getting a lot of the large custodial banks to give you that type of sanction. I spent probably 3 or 4 months of my life once trying to get 4 European custodial banks to do that, and I still couldn't. The best I could get was a sanction to negotiate. New York allows you to bring suit in the beneficial owner's name. So in one of those cases that was stricken out in Cayman, we simply turned around, refiled the lawsuit in New York, and said, we are the beneficial owners of these interests, and we moved on with life. One of those areas where I think in some respects very simple, a very common sense application. Ultimately, it's obviously the beneficial owner who has the interest, but it's that very strong line in the offshore jurisdictions that is rigid, I would say, and less elastic, that maybe gives you a little more, we'll say, access to justice, if we want to be kind, in the United States. Just a few other things to remember in the U.S. jury trials. We're entitled to jury trials on these claims, and that can have a huge impact on a defendant's willingness to settle. Because what might seem commonplace and ordinary to a judge may seem extreme to a jury of the fund managers or whoever's peers. You know, when you have a jury composed of ordinary folks who live very regular lives, listening to the travails of people who, you know, have made off with hundreds of millions of dollars, you may get a better result than you will just arguing your case before a judge, and something that's not available, obviously, in the Commonwealth system. I was going to go into jurisdictional issues, but if you want to add anything, Colette, go ahead.
No, I mean, we've got up on the slide there the benefits of US litigation compared to perhaps offshore Commonwealth countries. But, I mean, there's a flip side to all of this, isn't there? You know, it can be a benefit to not have a loser-paid jurisdiction. But, if you've got a very strong case, you might be quite glad to be able to get your costs back. I can't say this with certainty, but the feeling I have, and I don't know whether you can comment on this, is that in fact the process in the US is more expensive because it is much more sort of overarching. The discovery process is so enormous that it must add to the cost. Now, your answer to that may be, well, not really, because we all settle, because it is going to become so expensive. But it does strike me that the streamlined pleadings, the clarity in the pleadings, and the much narrower focus on discovery does mean that the costs are much less significant.
I think they could be. I think two things cut against that. One, you put your finger on it, Colette, and that is the cases tend to resolve sooner. There's also less fighting over fees. I shudder to think how much money is spent in fees fighting over fees, but that's a separate issue. And then the other thing that plays into it is, for the large part, ironically, the billable rates are actually a little bit lower in the United States. We don't have QCs. We don't have to worry about those types of issues. So there are benefits. What I would love to do someday, but I'll never be able to get access to the data, is to examine, fee approval petitions and liquidations and look at litigation that's been brought in the U.S. and litigation that's been brought in other Commonwealth jurisdictions, and try to compare and contrast the fees that are being paid out to the different lawyers. I think that would tell us a lot.
Now, you touched on getting access to records there, and that just reminds me there is a difference as well in terms of what's available on court files to people who are not parties to the litigation. Certainly in Cayman, the only documents you should have access to in a litigation context is the original writ, and sometimes you have the statement of claim endorsed on it, sometimes not, and also the judgment. You should be able to get that, but you shouldn't be able to see anything else. So affidavits, exhibits, that kind of thing, you just won't get access to that. So it's certainly not as private as the arbitration process, but it's not played out in public.
And it's very frustrating in this respect. I mean, I've had cases where you may have a large investor in a fund, an offshore fund, and a different investor has filed a winding up petition. And as that investor that has a large stake, you don't have access to the court materials and the documents. You have the fund manager telling you that, you know, a bunch of greedy SOBs are trying to take over the fund, and that's why they filed the winding up petition. And the greedy SOBs will then be telling you the fund manager has committed all kinds of wrongdoing that they've uncovered. And you really have no way of getting to who's being blunt, who's telling you the truth, because the only way to really get access to the court documents is to join one side or the other and to join the litigation. But once you join the litigation, you're on the hook for a fee award. And so talk about chicken and egg. How do I know which side to join if I can't have access to the documents? But if I had access to the documents, I might know. So it really is a different system. In the United States, everything that's filed with the court is public record, available online for the most part. Reporters have access not only to those records, they have access to the courtroom. The deposition transcripts are not filed, but they are certainly public unless there's an order prohibiting it. It can be shared with others. So it is a big difference, and it can provide, you might say blackmail, I would say maybe provide some leverage. If you've got somebody who's been a bad actor, the reputational risk of those types of materials being in the public domain certainly lend itself to early resolution. Quickly, just want to say the New York banking system is a jurisdictional mousetrap. Those are my words. We're seeing more and more, you know, Colette made the joke about you make a phone call into New York. Well, it's even worse than that. We're starting to see, in some respects, New York courts exercising jurisdiction if any of the funds have moved their way through the New York banking system. And it's very difficult to have an offshore fund operating in the financial markets without having any of the money moving through New York.
Well, every Cayman bank has a correspondent bank in the US, so at some point there will be a touch point there.
And that touch, not every case, but there are some cases now that are using those touch points for jurisdiction. So beware of that. I had one matter where a large European bank, wholly European bank, invested through an offshore fund, ends up in New York as a defendant, and, you know, literally looks like Alice in Wonderland. You know, what am I doing here? I've clearly gone down the path. I don't know where I am. I'm suddenly in New York. What happened? I'm a European bank. I invested in a Cayman fund, and I'm being sued in New York.
Well, hopefully they didn't agree to submit, and there'll be issues on enforcement in due course.
Exactly. The one thing I wanted to say here before we move on is beware in paridelicto. We've talked a lot about how flexible the U.S. court systems are, how wonderful New York is to plaintiffs. This is the one doctrine which seems to survive no matter what. And for those who don't know, in paridelicto is a doctrine that says essentially those with dirty hands cannot benefit. So you basically stand in the shoes of the wrongdoer. And in this case, what we're talking about is if a liquidator tries to bring a claim in New York against somebody, and the fund itself was run as some type of fraud by the fund manager prior to the liquidator coming in. You may have an paridelicto problem, because what the court will say is, I don't care if you're the liquidator or the fund manager, it's the fund that's bringing the claim, and the fund has acted in bad faith. The fund has unclean hands, and therefore it's the fund that's not going to be allowed to recover here, even if it's the fund manager, him or herself, that committed the wrongdoing. And that's a very strict doctrine, and there are ways to get around it practically, but you have to have lawyers who understand the doctrine, and you have to plead very carefully, because you probably can't avoid it ultimately, but you can certainly plead around it in the initial part of the case to at least get to discovery and try to figure out whether the claim is worth what you think it is. Just wanted to highlight this for a minute, and yet this plays into that cultural difference we talked about, that in onshore litigation, our goals are not always simply to get money back. There are other goals which litigation can't accommodate directly, but can accommodate through settlement. We've used litigation in the U.S. to get enhanced liquidity, to get a fund manager to free up some cash that could be freed up. We've used it to reduce or defer management compensation. It is amazing when you really push a fund manager on the 220 fee structure in a locked up fund, how quickly they will agree to lower some of those fees if they have to. We've done them to get independent valuations. We just simply don't have any faith left in the fund manager, the auditors, or the NAV process, and we want to have an independent forensic accountant come in. You can get that. Redemptions in kind, not always the best, but if you've got sophisticated investors who can trade on assets that are not easily tradable, redemptions in kind can be useful. We can get control of the fund. Some of the funds have removal provisions for managers. That's more common in the private equity space, but there are some hedge fund agreements that have that as well. And then lastly, sometimes our clients want to bring litigation, even if they think they may not ultimately be able to recover very much, because they may have a fiduciary duty to their ultimate beneficiaries. It may be a pension fund. And at the very least, they want to figure out what happened here. We don't just want to write off a $1 billion loss or a $500 million loss. We may need litigation to determine what went wrong, how did it go wrong, and who's to blame and who's at fault. And so I just throw that up there to say the court can't give you any of these things, but the litigation process itself can provide you with leverage to negotiate these things. And these are actual examples of things we have been able to negotiate onshore in cases that we've brought.
And I think that probably all comes from the willingness to settle, because the consequences of not settling are so much worse in the onshore space.
Correct. These are just considerations. We've already really talked about them. And this is the slide we really would like to talk about before we close today. Do you want to go back?
Yeah, no, you carry on. No, I don't need to go back to that one.
Let's do it in reverse order. Chapter 15, most of you have heard of Chapter 15. And Colette's probably an expert at this point on Chapter 15. It can be expensive. And one issue that comes up in Chapter 15 that could be difficult for liquidators is whether or not by filing a Chapter 15 and opening a placeholder here in the United States, you've subjected the fund and its interests to jurisdiction in a way that maybe you would not have if you didn't bring it. Colette, I know that's an issue you face all the time.
That is an issue, and the other issue we have is the Comey issue, and whether or not it's going to be accepted if you've got a Cayman liquidation that you have your centre of main interest in Cayman. We have cases on both sides of the line that most of you here will know. The most recent Morning Mist Fairfield Century has made it clear, I think the Second Circuit, that you can rely on the period in which a Cayman liquidator was in office to show that the Comey is in Cayman. And that's all very well where you've had an office holder in place for some time, but sometimes you don't have the luxury of being able to wait. Bear Stearns being an early example of that. They needed to get Chapter 15 recognition quickly, and they, as you all know, didn't get it. So we still have some issues with Chapter 15 and Comey, but I think the courts are, and certainly Onshore, are all trying to help work that out at the moment.
Right. The reason we're talking about this is we wanted to contrast it a little bit with Section 1782, and I'm going to ask you to do something I don't usually do, but if you'd indulge me, just a show of hands, how many people here know what Section 1782 is? Yeah, it's a small percentage. It really is. Section 1782 is a provision in the Bankruptcy Code that allows a foreign main proceeding, in this case essentially an offshore liquidator, to come into the United States without filing for Chapter 15 and to take discovery of parties that may have information that they believe could be relevant to their liquidation. And we've used it many, many, many times. All you have to have is a liquidator who can say, I am the liquidator of this fund is in liquidation in Cayman or BVI. I need documents from Deloitte, from Pricewaterhouse, from the fund manager, from whoever, because I need those documents in order to assist me in my wind down of this fund. And those documents reside or exist in the United States of America. And what Section 1782 allows you to do is file a petition with a court. It's not a lawsuit. It's simply a petition asking for discovery against that party. And the courts usually allow them. And once you have that sanction, you can obtain documents from that party and you can take depositions. So it's extremely useful for liquidators, an extremely useful tool, because you may want to bring suit against, for example, a third party or an auditor or somebody, but you really have no information. And it allows you to get that information. Or you may want to bring suit against another third party and the data just simply exists in the U.S. You may use it offshore, you may use it onshore, but what we're doing more and more when liquidators say to us, hey, we're interested in Chapter 15, what we'll say to them is, well, we can investigate Chapter 15, but 1782 may be a much more focused and cost-effective way to get what you want. If all you really want is to be able to go after some documents and information in order to determine whether suit makes sense, 1782 is quicker, it's cheaper, and there's less jurisdictional risk than if we file for Chapter 15 protection.
And for example, you can get a lot of bank records using 1782. I mean, we know that's been done.
Correct.
Certainly in Cayman, there was a decision a couple of years ago, Phoenix Meridian. There was a lawsuit going on in Cayman. Two of the witnesses in that lawsuit who'd given witness statements were subjected to a 1782 application for oral discovery deposition. I'm not sure what the term is. They went to the Cayman court to get an anti-suit injunction, saying this is outrageous, this is duplicative, we're already witnesses in these proceedings, they shouldn't be able to use this deposition process in the US. And the Cayman court had no sympathy, and the Cayman court actually relied on that unloved and unwanted orphan that I referred to earlier, which is the provision that allows for depositions in rare cases, and said that they would be very slow to interfere with the rights of a plaintiff or petitioner in the US, where they're exercising rights that they're given there, and they refused to grant the injunction.
Well, and the same is true in the U.S. I have a matter where I represent a fund. It's an offshore liquidation, and we filed a 1782 application here in the U.S., and the party that was the subject of that application said, Judge, we're already in litigation with that fund in Europe, and the only reason they're doing this is because they want to get through you what they can't get through the disclosure process in the U.K. To which the judge said, I don't care. The statute allows them to do it, and I'm going to allow them to do it. Now, whether you could use that material you find in the United States in the UK proceeding is a whole different story, but the courts have rejected this concept that somehow this is trying to get around another jurisdiction, because we simply say, this is a liquidation proceeding apace in Cayman or BVI. The liquidator needs the documents. The documents are here in the U.S. We're entitled to them. And it doesn't matter that there's litigation in other jurisdictions.
Well, I think our time is up.
It is.
So...
We're going to leave time for questions. We have about a minute or two.
Yes.
Are there questions? And if we run out of time, we can answer them outside as well.
Any questions? Very good.
This smart room, there's not one question?
Thank you.
Yes, there's a question. See, you got to prod them a little sometimes. Yes.
It's not a question entirely, but a comment that I make it on the issue of cost. Many times when dealing with foreign clients, they're afraid of cost orders. And I like to remind them that though cost follows extent, it's discretionary. Yeah. And the court may say each party bear their own costs.
Absolutely.
In appropriate cases, they can say to an attorney and give them an opportunity to be heard that you bear the cost in this litigation.
Yeah, in fact, that happened in a case involving a pleading of fraud, where it was said that there wasn't sufficient information, and it went to the House of Lords on whether or not the attorney in that case in the UK should pay the costs.
You know, let me just comment real quick too, which is we've been talking about these cost orders. There are provisions, even in the United States, where you have to pay the other side's costs, and I've had some of those. If you bring a truly frivolous case, you would have to bear the other party's costs. And sometimes, if the court determines that there's been a violation of what we call Rule 11, which is the attorney signed a pleading which he or she knew to be not true, then they can also sanction the specific attorney and say you have to pay. So that is true. It's just so much rarer here than it is anywhere else. All right, so we'll be outside. Go ahead, what's that?
And there is one other one, secure, if I may say this quickly. Often my foreign clients will afraid, but it's only ordered if the court finds it just to do so.
Absolutely right.
And security, when ordered, is not supposed to be oppressive or made to stifle a genuine claim. The court takes into consideration all of those factors.
But just in answer to that, in order to avoid being made subject to a security for costs order on the basis of impecuniosity, you have to actually give quite a lot of information as to your means and why you can't afford it and why you can't get the money from anywhere else. So, and some people don't want that intrusion. Some people really just try and, desperately find the money rather than saying, here are all my assets, because it's quite intrusive.
Right. I think they're going to give us the hook. So
Very good.
Thank you, folks.
Thank you.
We'll be here all day. Take care.